Hello, I'm Robin from Seoul Law Group, and we're an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover everything you need to know about Jeonse housing deposits in Korea. Let's suppose a case. You've been living as Jeonse for a long time, and the contract period is about to end. You found another house, and now you should move out and ask the landowner to return the deposit as you need to pay for the new deposit. Then your landowner may say, if the next lease comes in, then I'll give you the money, and now you're in big trouble. In this video, we're going to overview what Jeonse is, why this problem happens, and what to do to not get slipped into this trap. What is Jeonse and the loophole of the system? First, we need to understand the unique characteristics of Jeonse. Jeonse is a very distinctive form of contract frequently found in South Korea. It doesn't even have any proper English name, so it's officially translated as Jeonse, or lump sum lease, which is not an accurate translation. This is how it works. You pay a lot of money in a lump sum as a deposit to the leaser. Then you do not pay any additional money, and the leaser returns the deposit to you at the end of the contract period, but no interest is added. As a result of the contract, the leaser gets to borrow a huge amount of money from you, the lessee, for no interest, and the money corresponding to the interest for the lump sum deposit works as the monthly rental payment. One of the biggest ironies of this form of contract is that most of the Jeonse named contracts do not fall under Chapter 6 of the Civil Act, Article 303 and under, which stipulate the true sense of Jeonse. Rather, most Jeonse contracts are just a modified form of lease, which is stipulated in Section 7 of Civil Act, Article 618 and under. If you're not certain about your contract's form, it must be lease. In that case, your contract shall be in effect only between the lessee and the leaser. Moreover, registration is not required. Your right for your residence shall not be treated as real right, but just as a claim. This causes two big problems. First, you cannot claim your right to the house against a third party. Second, you do not have any security if you've already moved out from the house. It's called delivery legally, while it may sound strange, and you do not have any measure to set up against the landlord. Two possible ways to contest: not to move out or to register. So what can we do when the leaser does not pay the deposit back to you? There are two legitimate ways to consider other than just filing a lawsuit. The first way to contest against the leaser is not to move out of the house at all. At the end of the lease contract, the lessee must move out from the leased object, and the leaser must return the deposit. These duties on each party must be concurrently performed. If the leaser does not pay the deposit to you, then you do not have to move out. The problem is, in most cases, you've already contracted another resident to live. You need to move out of the previous residence and move into the new one. It won't be easy to cancel the new lease contract, and moreover, when the previous leaser gives the money back to you, then you need to move out. You will be in an insecure status, stuck in the middle, not canceling the new contract, yet not moving out from the previous house, waiting until the landlord gives the money back. The second and recommended way to contest is registration. We've already mentioned that registration is not required, but this does not mean that registration is impossible. This system is stipulated in Housing Lease Protection Act Article 3-3. As you can see from the title of the Act, this is to protect the house lessee. The requirements are simple. 1. The lessee has obtained the opposing power. 2. The lease contract is terminated. 3. The deposit is not refunded. In that case, you can file an application for a leasehold registration order to the district court. As it is just an application, not litigation, it mostly only takes 2 or 3 weeks for the order to be issued. Once a leasehold registration order is issued, there are a few benefits to the lessee. First, your opposing power does not vanish if you have moved out. Second, you get to obtain a preferential repayment right for the house. Therefore, once the object is auctioned, then you get to be paid from the proceeds from the sale. Last, and the most important effect of the leasehold registration order is that the record remains. There's no lessee who wants to lease from an unreliable leaser. Once the registration is done, the record regarding the registration shall be permanently on the record, even if the deposit is returned. Another registration that the order was cancelled shall be recorded upon the previous record. This shall be an indicator for the possible future lessee to check the credibility of the leaser and can decide to avoid the leaser with the registration record. In general, the lessee has a high possibility of being endangered or stuck in the middle. By House Lease Protection Act, it's possible to have your leasehold registered and have your deposit be refunded. For that, 3 elements are required. 1. The lessee has obtained the opposing power. 2. The lease contract must be terminated. And 3. The deposit is not refunded. Seoul Law Group has various experiences regarding house lease contracts, including Jeonse. Especially, the leasehold registration is a relatively quick procedure, so we can help your deposit to be returned soon. Please do not hesitate to contact us. Well, I hope this video was useful for you. If you have any questions or concerns about Jeonse deposits in Korea, let us know in the comment section below, and you can find more info on seullawgroup.com. Don't forget to like, subscribe to our channel, and turn on that notification bell for more Korean law videos, and we hope to see you next time. Goodbye.